Good afternoon, Mary Rubio on behalf of Ms. Webster.
Okay. And Ms. Webster, your name?
Keisha Webster.
Okay. And so we're here for a probation violation hearing in this matter. On probation for operating with a high BAC, which is a maximum penalty of 6 months in jail. And of course, you asked for a lawyer, so that's why we have Ms. Rubio here today. You're entitled to have a full hearing on the matter. The allegations, again, go back to January 24th, when it was alleged you at an alcohol consumption event on a Scram Tether on January 3rd, 2024, 6:04 a.m. And then it was amended again on January 25th to state that you had another confirmed alcohol consumption event on your Scram Tether, January 13th, January 21st, and January 24th. And I believe that's why we're here. Okay, so of course she can have the hearing or plead guilty. So how would she like to proceed?
Your Honor, I have spoken at length with Ms. Webster prior to today, as well as today. I've also spoken with her mother, who is present. I was also just now speaking with her probation agent. I've also spoken to her prior to today.
And you know, this is the second violation.
I am unfortunately aware of that.
The
Now-
first one was apparently positive ETG test. I guess that's how she got the Scram, and failure to appear for ETG test.
Yes, yes, I was made aware of that.
Okay.
I was speaking with her probation agent prior to today, as well as today, just now. Now, today is the first time that I was able to see the report, as well as the somewhat voluminous documentation that comes along with the Scram Tether reporting that sort of explains the TAC reporting and a little bit of the science behind it and that kind of thing. I will tell you in all honesty, and I did tell my client that I am really not as familiar with Scram Tether as I would like to be. So that is one reason why I would like to ask for a 30-day adjournment, but this is what I proposed to the probation agent. Now, it is my understanding
So you would
that
like a hearing, you think? You want somebody from the agency, I think it's EMS.
He's here, Your Honor.
Oh,
From home confinement.
oh, it's home confinement, okay.
yeah, I need to get the discovery. I need to review it.
What discovery? It's just a test.
the-
So he might have the readouts from the testing.
This is, okay, let me just say what I'm saying. I need to review it. I need to understand it a lot more. I really don't. I honestly, prior to.
Well, let's do this, but hold on.
And then I have a suggestion also.
Okay, what's your suggestion?
Okay, this was gonna be my suggestion. It's my understanding that, and I'm sorry, I don't know if you, has been fairly accommodating to my client so far throughout this process. Prior to this month, my client did not have a car, and this is my understanding as to kind of why she placed my client on this type of tether, because she was having a difficult time.
I ordered it, that's why she got placed on it,
Okay.
from the first violation.
Was she on a different type of alcohol testing prior? to
Yeah,
this?
ETG test.
Okay, and I'm sorry, ETG testing.
That's just like a urine test that they do to confirm alcohol consumption. And then it can be a ETS test is even more confirming of that.
Okay.
And the
so-
ETG test typically goes back with the 48 hours.
Okay, and then from a positive urine test, which was the first, the first violation, then this was ordered.
Yes.
Okay,
And she was ordered to go to common ground apparently. Too.
Yes, and this is what I wanted to indicate to your honor. My client has advised me that as of this month, she has obtained a car. She was on a waiting list through Common Ground.
Okay, well, what are we doing? I got a man here waiting to go home or testify. I mean, do we want to have a hearing or what do you want to do?
Okay, this is what I'm trying to do. What I'm suggesting is that if we adjourn this matter out for 30 days.
To do what?
During that time period, a couple things will happen.
Okay.
My client, as I was stating, my client was on the waiting list for Common Ground, and unfortunately, due to some kind of an error, got removed. She's back on it. However, she has since been admitted to a different program. I could give the court that information. But what I would like to do during that 30-day time period is we can do two things. I can prepare for the hearing, but additionally, during that time period, my client will have, based on what she represented to me, be enrolled in the program that she's been accepted to, which is the National Council on Alcohol and Drug Dependence in Detroit on Wyoming and McNichols. Since she has a car, she will be able to attend AA, and she will be able to come back with proof of these things. Additionally, I will be able to get copies of each of those reports. I guess since I was not aware this gentleman was here, I don't know if I can get them from him. I don't even know if the probation agent knew he was here. She was telling me I could call the company, but I guess I don't need to call companies. He's sitting right here.
Sitting right here.
So-
I'm sure he has something he's gonna testify.
So I could get the reports, and then I can review them, and then I can learn about them in the interim myself. But that's what I'm suggesting that we could do during this time frame. It would give her a chance to at least give some kind of a show of good faith work, because I understand there are these violations, but in addition, when I looked at the report, which shows completed, missing, and remaining, there's really very little that she's done, and I just wanted to give her a chance to demonstrate something.
Which she has had.
That was my hope.
And on probation, this is not new. She got on probation September of 2023. So she had time to show me some good faith, especially after the first violation. But you're asking me to adjourn it for her to do the things that I ordered her to do after the first violation, which I'm not inclined to do that because I reordered it. And before she could get that done, she has more alleged violations.
Okay, well, that was something I was hoping, but in addition.
But I would be willing to do this. I would be willing to pass this matter, but you talk to the gentleman here, see what he has, and understand what he's gonna say the science behind this is, and perhaps you'll be prepared to go for hearing today.
Okay, can we do it at 2:30 then, or 3 o'clock? Because I'm gonna need to call some people and talk to some.
I won't be able to do it at 2:30 because we have a civil docket. So prosecutor won't be here.
Okay, well, how late can you do it? Because I've literally never done this before, and I need to call some people to be able to adequately represent this individual who's facing jail time.
Okay, so why don't you do this? Go talk to him, see what he says, then make a determination who you call, and I'll recall the case and we'll see where you are. How about that? Okay? All right, so we're gonna pass that and.
Mr. Grace is in the back. You want me to get him out?
Okay, so we're back on the record here with Keshawn Webster for the probation violation hearing. My understanding after brief bench conference, Ms. Rubio, is it your client? No?
No.
Okay, well, what do you want to do then?
We're prepared for the hearing.
Okay, you want to do the hearing now? Call your first one.
People call Austin Roman to the stand.
Okay, raise your right hand. You solemnly swear from the testimony about to give be the truth, whole truth, nothing but the truth.
Yes, Your Honor.
All right, thank you, and have a seat there, and of course, keep your voice up so we can all hear you.
Do I like turn this on?
No, you good.
You know
Okay,
what,
all right.
that doesn't do too much
Okay.
to amplify. It is recording though.
Got it.
Please stay and spell your last name for the record.
Austin Roman, AUSTINROMAN,
How are you employed?
home confinement.
What do your duties entail?
I'm a business development supervisor and court liaison
How long have you been employed there?
of over 4 years.
It's part of your, it's part of your duties to monitor probationers who are assigned to you.
Correct.
Um, Were you charged with monitoring a scram tether for Keisha Webster?
Correct.
What is a scram tether?
It's like a breathalyzer that sits on your ankle. It takes a test approximately every 30 minutes to test the sweat vapors for the presence of alcohol.
Do you know how it tests that?
Briefly, yeah. There's a fuel cell inside of the device. The pump inside of the device takes a sample of the sweat vapors and it exhausts it out of the bracelet.
Does scram tethers have an error rate? Are they 100% accurate?
I believe it does have an error rate. I think the error rate is about 1/10 of 1% in terms of false positives.
Concerning Ms. Webster's scram tether, was there any detections of alcohol?
Correct.
On what dates were there detection of alcohol?
If I could refer to my notes.
Yep.
Because there's 5. 1/2/2024, 1/3/2024, 1/20/2024, 1/23/2024, and 2/27/2024.
All right, let me make sure I got that 2/20 of 2024.
No, I'm sorry, it's 1/2/2024.
Wait a minute, 1, 2.
Sorry, I'll skip the 20.
We also,
January 2nd, let's say.
Correct, all
we
right,
also
January.
saved the amount of alcohol on that date as well that was detected.
Yes, so on January 2nd, we'll go slower.
Okay,
Okay, all right, so on January 2nd, 2024, the peak TAC that was established was 0.035. And I'll
when you
just
say TAC, what is that?
That's transdermal alcohol concentration.
Transdermal alcohol,
Correct, concentration.
okay? 0.035,
Correct, that was the peak that was established.
okay, next.
The next one would be January 13th, 2024. And on that date, the peak would have been a 0.153. The third one would be January 20th of 2024. The peak would have been 0.056. The next one would be Tuesday, January 23rd. The peak would have been 0.042. The last one would be February 27th of a peak TAC established of 0.071.
And what do those THC percentage means? As in, do you know what that would correlate to blood alcohol content?
I would not, I'm not an expert in blood alcohol content.
Are these amounts that are reported, the 0.153, 0.056, 0.042, is that above the error rate for this device, if you're aware?
Well, the error rate would be something different than the TAC levels.
Have you ever seen a scram tether erroneously alert?
Pardon?
Have you ever seen a scram tether just go off when someone has been drinking?
No,
And how long have you been doing this?
4.5 years.
Are there any other reasons why, let's say, someone drank something like mouthwash that wasn't an alcoholic beverage, but still had alcohol, that would still show?
Well, it has to meet the
Does it
strict,
have a cutoff?
yeah, well, it has a strict criteria, Scram does. It has to establish a base TAC twice before a consumption event. It would have to establish a peak TAC, which I provided all those numbers to you. It would have to reestablish a baseline of 0.00. It would have to have an absorption rate less than 0.100 TAC per hour,
Rate less than what?
0.100 TAC per hour. That's the absorption rate. The elimination rate must be less than or equal to 0.035 TAC per hour. And then it also needs to pass the environmental contaminant test.
Which means nothing else could possibly give you a false positive. Is that what you mean by environmental?
Correct. We give the benefit of the doubt to the client. So if environmental were to play a factor in an event, we would automatically throw that event out.
Okay.
What are those environmental factors?
I mean, it could be any sort of thing that would contain alcohol that would be near the tether.
So let me understand this.
What about like lotion with some alcohol?
If it was near the tether, it would have to meet all the criteria in which I provided.
Okay. Was alcohol
Correct.
consumption.
Correct.
Okay.
So basically, just to make sure I understand this correctly, with the Scram Tether, you have this on, you drink alcohol, it checks for, it starts with a baseline. So when you first get it on, assuming you haven't been drinking when you get it on, that's your baseline.
Correct.
Then it watches
Approximately.
the THC go up until it hits a peak. And then it continuously checks every 30 minutes to see if it's expelled or goes down.
That's where the absorption rate and the elimination rate would come into play.
With the scientific understanding of how alcohol is absorbed in the body until you get back down to the baseline.
Correct.
And then it only alerts if all that's met and the environmental test is correct.
That is correct.
I don't have any further questions.
Cross-examination.
When these Scram tethers alert that alcohol has been consumed, is that the language they alert that alcohol has been consumed?
I would have to double check, but it just flags in our software as a positive alcohol consumption event.
Okay, is there anything that is done after that by your company to verify positive alcohol consumption? Do you or someone with it's home confinement, correct?
Correct.
Do you or someone within home confinement then call the individual to have them submit to some kind of further testing?
We would not do that. I don't know if probation would have done that or pretrial, but that's not our job duties.
You don't do anything like that. Okay. Do you know if when there is a, I'm sorry, one more time, the language positive, when it says positive, confirm alcohol consumption event. When there's a confirmed alcohol consumption event, is there something then with the Scram tether that will then try to test again for alcohol within a shorter time period or anything like that?
Well, it takes the test approximately every 30 minutes.
The whole time anyone is on a Scram tether?
Correct. Yeah. Continuous alcohol monitoring every 24 hours, 7 days a week, 365 days a year, approximately every 30 minutes.
Okay.
It could be sooner, it could be more.
Okay. And you already gave us the dates and the times and these specific instances, and you indicated that, hold on. you have on um, these reports are reports that are automated reports produced by the Scram program. Is that fair to say, or do
Well,
you produce them?
Yeah, I produce them.
Okay, so a moment ago, you spoke about an incident that occurred on January 2nd. If you refer to your own report, would it be fair to say that you misspoke and you meant to say January 3rd?
Well, no, because she was just asking me when the event started. I gave the peak levels, not the peak dates.
Okay, because when I look at it, it says a baseline of TAC of 0 was established on January 2nd.
That is correct. I gave all of the dates of the baseline and then
Oh.
just the peak TAC levels, not the dates.
Okay, okay. And then a peak TAC, which I guess would mean there's some sort of the alcohol consumption event perhaps of 0.035% was established Wednesday, January 3rd at 6:04 a.m. And then 0 TAC was reestablished Wednesday, January 3rd at 8:37 a.m. So basically 2.5 hours later, there's 0 alcohol. Is that correct?
Correct.
Okay. Now, these Scram tethers don't test specifically for, I guess what, to put it in layman's terms, what we generally look at as alcohol that everyday people consume. Is that correct? Is that called ethyl alcohol? Is that what?
Ethanol, but I wouldn't be able to tell you which specific alcohol, just that there was an alcohol consumption event.
Okay, so I guess, for example,
It picks
Scram,
up any sort of alcohol.
any sort of alcohol, a Scram tether can pick up any sort of alcohol. So when the judge made reference a moment ago to, I think she said, to like hand sanitizer, for example, technically speaking, if someone spilled a bottle of hand sanitizer onto their tether, I'm sure that would be unusual, but it would pick that up.
Correct, but it wouldn't be a positive consumption event.
Okay, it would, what would it do?
It would just throw the positive event out. It would give the benefit of the doubt to the client.
So literally nothing would happen. There would be,
I mean, it would trigger something in our software saying there was alcohol detected, but it wouldn't be confirmed as consumption rather than environmental.
so you're saying this Scram tether that is worn on the ankle can actually tell whether a human physically swallows alcohol versus whether or not it is put anywhere on the body. That's your testimony here today.
That would beat the 6 criterias, then yes.
The 6 criterias.
Yes. So a 0 or a baseline of 0 needs to be established before the event. Peak TAC needs to be established. A 0 needs to be reestablished. And then it would need to match the absorption rate and the elimination rate, and then the environmental contamination test or contaminant test.
And do you have any personal knowledge due to your employment through home confinement, if this defendant, Keyshawn Webster, is on any other type of monitoring for alcohol consumption?
Yeah, I would not know that.
This is your only role as far as this case is monitoring of this scram tether
Correct.
and the events that you just now testified to.
Correct.
Did you also have some issues as far as it having to contact attempting to contact the defendant as far as a fit issue, that the tether fitting improperly or no?
Correct. Yes, there was.
And were you able to fix that?
Correct.
Did you have to do that more than once or just once?
Just once.
Do you recall when that
I
was?
believe it was on the 2nd or the 3rd of January.
Okay, you were able to get in touch?
Correct.
With the defendant? Okay. Did she come in or how does that work?
Yeah, she would come in, and we would do the fit adjustment, whether, what needed to be done. And then they just leave. It takes like 5 minutes, approximately 5 minutes.
Okay.
But yes, on either of those 2 dates that I said, Keyshawn would have been present at our main office.
Okay. And as part of the program to be fitted for this scram tether, do you advise individuals who are being fit with a scram tether to avoid a number of products that contain forms of alcohol?
That is correct.
I don't have any other questions.
Any redirect?
Yes, but indirectly, Your Honor, are you able to take judicial notice of supplemental orders by probation?
If they're in the file,
You have a supplemental order by Brianna Moore dated December 28th, 2023.
the last thing I have in December is December, actually. December 14th, there was a sentencing. Is it an order that I signed?
No, it's an order from the probation of Ms. Moore telling her to go to Electric Monitoring Systems, Inc.
Well, I don't have that. Maybe that's something that she wrote, but
Okay.
you can get her here. She's here today.
We're fine. I have no further questions for this one.
Okay.
Thank you.
Can I step down? Thank you. Any other witnesses for the people?
Oh, yeah.
Any witnesses for the defense? Any witnesses for the defense?
No, you're,
Okay. Argument then?
I think we have proven even beyond a reasonable doubt that that was the standard that these alcohol events did occur. She was ordered to scram monitoring. She had the scram attached to her. The alcohol consumption events, all 5 of them are confirmed events. Increasing and lowering over time. And she did in fact violate her probation. Again.
yeah.
Yes.
Your Honor, we heard obviously from the one witness from, prosecution who, from what I understood, works for a, Tether company. He was not qualified as an expert, is not an expert as I understand it. He gave, no point of reference as far as, what TAC is. He talked about TAC, he told us what it stood for at one point, talked about it briefly. He gave the dates for quote, positive, confirmed alcohol consumption. Then he also testified that the question from the prosecution was, and I quote, "Have you ever seen scram tether erroneously alert?" He stated no. In the entire time that he's been employed, he's never seen that. I'm certainly not, I do not want to call, I'm not calling him a liar, but I find that difficult to believe. What I'm indicating that I believe that he can't possibly know that. He can't know that everyone in his employ that.
He said he didn't say everybody in his employ. He said he's never seen that.
And it's impossible for equipment to not ever fail. Equipment is only as good as the people who.
Well, what other evidence do I have other than what he said that he personally has never seen that? And that could be
Right.
possible.
And that's obviously something I just wanted to point out, and that's very well, Your Honor can obviously consider that. And we have, as he also indicated that these individuals who are placed on a scram tether are told to avoid various products that contain alcohol, but yet he also indicated that this monitor will know if you consume alcohol, and it will only alert if you consume alcohol, that there would be no problem if you spilled an entire bottle of whatever it was, hand sanitizer, rubbing alcohol on the tether. I just find it difficult to believe that. I just don't think that there's been proof, even by a preponderance, that we can believe that this individual has violated this tether, that she has drank alcohol, that she's consumed alcohol 4 or 5 times. I will indicate that it's the people's understanding from the documents. I don't think that it matters that much, but from the document that I've received as far as the second technical violation of probation summary report from the probation officer, Brianne Moore, that this is regarding, I believe, 4 incidents, and they're all dated in January, that the February 27, 2024 incident wasn't technically a part of the second violation. But anyway, I just don't believe this is proof that this can be proof, even by a preponderance, that this individual is guilty of these violations.
Well, the interesting fact about the whole thing is that he said what he said. There was no question that even was posed that really affected the credibility of what he was saying. There was no evidence presented to the contrary. So we've got what we got. testimony wise, the speculation as to whether or not counsel would have trouble believing it is not the standard. It's like, what do we have on the record? And was there enough questioning or poking into the cross-examination to, put the witnesses, credibility at issue? And I didn't see that. I mean, Mr. Roman came across as knowledgeable about what he knew about this particular unit. And he's steadfast. He knew the 6 factors that the machine has to go through in order to even give a positive readout.
And he wasn't qualified as an expert. I just want to make that.
No, he's not an expert, but he doesn't have to be an expert. He can't give what he knows through his training. I don't know who the expert would be, the manufacturer of the machine maybe? But you don't need the manufacturer of the machine to establish a probation violation for this. You just need somebody to tell us how this machine works. If they test the machine in some kind of way, and he did talk about how the machine tests itself. He told us about how all these factors have to fall into place for the test to come back positive. So I don't really know that his credibility is questionable simply because, he's trained to know the basics of how the machine works. He didn't manufacture it, of course. Did the people wish to make any additional argument before I rule?
No, Your Honor.
Okay. Well, Mr. Roman, Austin Roman from home confinement came and patiently waited today to give his testimony about the Scram Tether that was assigned to Keshawn Webster, that he did monitor that. He is the court liaison and business development supervisor for over 4 years at home confinement. He told us that this particular tether sits on the ankle and it will test every 30 minutes, test the sweat for the presence of alcohol. This is sweat from the person's body. He's also said that that there's some kind of cell in the device that takes the sample of the sweat and then at some point exhausts the vapor out of the device. He said the error rate for a false positive was 1/10 of 1%. So that's a pretty low error rate. He says in this particular instance, alcohol was detected for Keshawn Webster January 2nd, 2024, January 13th, January 20th, January 23rd, and February 27th. He testified that those were the dates where he had originally seen the baseline of 0. And then apparently thereafter, maybe within that day or the next day, there would be a test that would show a peak. And for the one when it was a baseline of 0 on January 2nd, there was at some point a peak shown of 0.035. A peak TAC is peak transdermal alcohol concentration. So this is the highest level of alcohol that would have been seen at that time coming through the skin, through the sweat. And January 13th, at some point thereafter, from the 0 baseline, there was 0.153. January 20th, from the 0 baseline, 0.056. January 23rd, from the 0 baseline to 0.042. And then February 27th, 0 baseline up to 0.071. He did testify that you have to have this baseline, then a peak transdermal alcohol concentration, then a 0 baseline has to be reestablished again. Then the absorption rate and elimination rate have to match. And then he says the environmental contaminant test has to be passed. And that if you don't pass that environmental contaminant test, then the person gets the benefit of the doubt that there could be something external to alcohol use that would have caused the problem. And it would basically, the machine would give you some type of, I don't know if it's a buzz or a light or something to show that it didn't. And then that would not be considered an event. And he said that the basic implication, because I asked, is that if it does pass all of those things, is that there was the presence of alcohol consumption And he said, yes, that's what that means. He also testified for the prosecution's question that he himself has never seen a scram tether alert when there's been no alcohol consumed. Not saying that the machines are not machines and can't have errors. He says he's never seen that. The testimony here was in this particular case, all the factors were present, meaning that there would have been an alcohol consumption. The questions were asked, well, what if you spilled the hand sanitizer on the machine? He said, yeah, we would see something, but it would not be a confirmed event because it would not, obviously, probably would not pass the absorption or elimination rate. It certainly wouldn't pass the environmental contaminant rate. So he says, even if they show something, that it would not have been considered a confirmed event. And he did say that the machine would know the difference between what would have been a confirmed consumption versus something that could have happened environmentally. And that's what he said. And that people are advised not to drink things that would contain alcohol. So, and that would mean that you're advised not to take things like, I guess the big one is NyQuil. People claim to take that has some alcohol consumption consumed in it at some level. So there's nothing on this record that would show the court that this is invalid information, that it's real questionable, and it doesn't make any sense. There's nothing like that there. So the court finds that this seems to be reliable testimony, and there's nothing here contradicting it. So I'll find the defendant by a preponderance. It's not a beyond a reasonable doubt standard, as the prosecution said, but he thinks he would have met that, but he certainly has met the preponderance of the evidence standard on the 1, 2, 3, 4, 5 test that came back positive for alcohol consumption. So guilty of violation. All right, so probation has recommended the ATI, Alternative to Incarceration program, with 5 of those 5 days in custody with 30 days in the ATI program. Do you wish to speak to that and the $100 violation cost, and definitely continuing the probation is what they're recommending? You wish to speak to that, Ms. Rubio, first?
I guess I would just renew my original, I don't want to say argument, but I know that,
First of all, this is a technical violation.
right.
So under the new rules, unless she wants to go to jail, I can't give her, 30 days in jail and close the case.
Oh, no, but I'm
That's
sorry,
what
that's
you
not what I was gonna say. I mean, I know she was hoping to, maybe to go to that new program that she just, was getting enrolled in, or, as of yesterday, she had talked to the people, and so I was hoping she could get a chance to do that, as opposed to, I know that that's what that ATI, is,
Yeah.
but so
That's
she,
exactly what it is.
but this is a program that she just found,
I don't know anything about it. though.
yesterday. It's, I don't either. I know she just told me about it, but it's called the National Council on Alcohol and Drug Dependence, and it's located in Detroit at Wyoming and McNichols. I don't know, maybe she could coordinate that with her probation agent. I would just,
Obviously, she's got a problem. She can't stay away from the alcohol. And so she needs to have some rehabilitative service. The ATI program is community-based. It's 24 hours a day supervised sentencing alternative for us to give. They have to adhere to a strict supervision and behavioral standards, participate in therapeutic interventions such as substance abuse and or mental health counseling, and they may be required to contribute financially if they're employed. They're encouraged to establish partnerships with community agencies to further assist them in meeting multiple needs. They do deal with Heartline for women only in Detroit and Turning Point in Pontiac. So. And they say that this is part of a structured sentence where they may serve some jail time before being released to the program.
I would just ask the court if it's at all possible for her to not serve any more jail time right now. I know.
I can't send her to this program without some kind of incarceration.
I know, I'm just asking, all I can do is ask the court if she can not do any additional.
This
jail
is her
time.
second
I
violation.
know.
Nobody ever wants, do people just want to violate the court order and no one ever wants to go to jail? Oh, please don't send me to jail. And I understand that's what the defense counsel have to do. But at some
Exactly.
point, you do have to pay the piper, so to speak. You have to live up to your behavior. If this was an alcohol treatment court, it would probably be a mandatory jail sentence of some days. That is the sanction. And then you get back up, you get on that horse, and you get back on your sobriety.
Well, if you do that, stand up.
And go to the podium if she does.
and State your name. Think about what you're gonna say.
What do you want to say, if anything, Ms. Webster?
My name is Charlotte. Like I was trying to say, like when I got out of jail on the 31st, I was sick. And I went to the hospital. And I got shots and they rub alcohol on you before you eat it.
That
Yeah, I'm
wouldn't,
just saying,
that
but
wouldn't kick this out.
ever since like the first incident, it's just like y'all.
That's an external factor, not an internal factor.
Okay.
So that would have not triggered the machine. based
Everybody
on
trying
the
to make it seem like
testimony.
I'm an alcoholic, which I'm not. Like I've been trying to enroll in programs this whole time. They saying if I haven't drunk within the 30 days or I can't be enrolled, I've been waiting for common ground. I've been trying my hardest to do everything I was supposed to do, and it's like, we just keep failing. What I just don't understand. How am I guilty of something if I'm really not? And I keep.
Well, you heard how you were guilty because you heard the evidence.
Okay. But that's just all I wanted to say to you.
People.
Yes, Your Honor. As Your Honor is well aware, the max sentence you can receive on a operating while intoxicated high BAC charge is 180 days. In correcting your sentence, the defendant has volunteered that she's not an alcoholic. She appears to not be remorseful for what has occurred, taking no responsibility. As you and I both know, first step to fixing the problem is admitting that you have a problem. She's not there yet. So the people would request that you do follow the recommendation. However, hold at least 60 days above her head. So if she violates ATI, she's going back.
Okay, so the sentence of the court here is going to be, I will do the 60 days. ATI program, she'll spend at least 5 of those days in Oakland County Jail, and I'll spend 55 of the days if she's in compliance. There will be $100 violation cost. And then we'll continue the probation otherwise. And with a $200, $150, I'm sorry, counsel fee.
Okay.
Okay.